So that pretty well settles that issue. Okay.
And I kind of give an explanation that maybe people would understand.
Well, that's pretty clear, I thought.
The court, by definition, is the person and suit of the sovereign.
Right.
When those two come together, they create a fiction called a tribunal, of whom the sovereign is in control. That's how. And the tribunal is just as fictional as any other court you're going to be in. But however, it takes the person and suit of the sovereign to have that tribunal at your disposal.
Right. But even though it's the person and suit of the sovereign does not have complete control unless he's the only one in the court. So if he hires a staff, then the sovereign becomes subject to his own court. Okay, so that's got to be careful who you hire. And when you're subject to your own court, don't grant any judicial functions to the members of your court. Okay? Now, it's true that a court is the person and suit of the sovereign, but that still does not define what kind of court. So there's many different kinds of courts. There's equity courts, admiralty courts, court of the exchequer, and courts of record. So we specifically have said here that this is a court of record. So that gives you the proper setting. Now, why is a court of record so important? The reason is very simple. It is the one court that is acknowledged by the Constitution. You see, other courts are not acknowledged by the Constitution. You can have any court you want, run it any way you want. It's your house, so to speak. But if you come up with a judgment and you want that judgment to be enforced with the help of the government itself is restricted. It can only enforce a judgment that comes out of an equity court or a court at law. The Constitution says that the judicial power of the United States is available for something to do with any court at law or in equity. Well, at law means common law, and equity means, of course, equity. So, all right. So anyway, then we name all the defendants. Okay. Who are each summoned to answer the said plaintiff in a plea of trespass and trespass on the case. And we kind of covered what trespass and trespass on the case was. And so then we have a little summary, the introduction. All right, so let's go back here for the overview. So you can see first we named the parties and the type of court, the form, in other words. And then we have the introduction. In the introduction, we write an overview of the lawsuit so that the reader has a perspective when he reads the details later. Then there's the actual body of the action, and you specify a cause of action, a set of facts which entitles the plaintiff to the relief claim. Okay? And we got a little footnote here, which shows up there. Just a little footnote. Right. Or we can go down to it where, see, that crunches it all together. But if we go to the footnote, it's not crunched so badly, but it's still crunched. Okay, but basically, this is all the case law that supports, or the authorities, you might say, that supports exactly what a cause of action is. So, it says that it's the fact or facts which give a person a right to judicial relief. That pretty well summarizes it right there. The legal effect of an occurrence in terms of redress to a party to the occurrence. A situation or state of facts which would entitle a party to a sustained action and give him a right to seek a judicial memory in his behalf, or remedy in his behalf. So it goes on. I mean, this is all the technical definitions of what a cause of action is, but basically it boils down to that you tell the story. This is what happened. This is how I got injured. And then there's the obligation. So we'll go back.
I don't recall reading that in Aurora's case. Did you?
Well, actually, if we go across over here,
Could you repeat the question?
he says he didn't. Yeah, go ahead. Repeat the question.
Well, I'm just saying I didn't recall reading that in Aurora's case.
Well, here it is. Whoops. Well, I didn't put the footnote. That footnote I created for that to explain what a cause of action is.
Yeah, well, I like that.
Yeah, but the cause of action was put in. So here's the introduction. Each kidnapper exceeded his jurisdiction by either directly through an agent or in concert with another did cause plaintiff Robert to be unlawfully and forcibly. I changed the names to protect the guilty. But this is the summary of it, okay? And it's reasonably long. You know. Yeah. Oh, did I leave her in there?
No.
Did I?
Yeah.
I thought I got that. He's keep down and so on. No, with another. All right. Where's her?
Your will.
Carried away against your will.
How about that? All right. Didn't volunteer. Nope. Says against his will.
I thought that's in a paragraph ahead of that.
Okay.
No.
You're right.
Did I hear a confession? Okay.
Yeah, I'm not sure where I saw her.
Got women on your mind, apparently. Okay, well, anyhow, so you have an introduction, and then in the introduction here, you basically just a little summary, or maybe even a big summary of what's going on, and then in the body of the action, you state a set of facts which entitles the plaintiff to the relief claimed. And then I go into detail here on this template of the different common law causes of action. So here's trespass, injury committed with force, actual or implied, immediate and not consequential. If property is involved, then property was in actual or constructive possession of the plaintiff at the time of injury. Trespass on the case is the form of action by which a person seeks to recover damages caused by an injury unaccompanied with force or which results indirectly from the act of the defendant. It is more generally called simply case. The word case by itself means trespass on the case. Trespass and trespass on the case are supplementary to each other, and it may be said that in general, trespass on the case lies where no other theory or form of action is available, though it is sometimes concurrent with other forms. So in Aurora's case, we sued for both trespass and trespass on the case. What one misses, the other one gets. So, then we have, yeah.
You don't have to be specific?
Okay. No, you have to be the question is, you don't have to be specific, and the answer is, yes, you do have to be specific. You have to say what happened, what the injury was, but sometimes it's a little hard to know whether you have injury, violence involved or not. Because see, if you're let's say you're stopped, you're on the road, and you're stopped by a policeman. Well, technically that's an arrest. Okay, you're not free to go. Even if he says you're free to go, just try it. People have found themselves arrested when they said, tried to walk off after the cop said they were not under arrest. So, when you are arrested, there is the threat of force, but you don't know for sure. So you call it both trespass, and you call it trespass on the case. Now, an interesting thing is this: there's another word that's used often in lawsuits. It's count. You have count 1, count 2, count 3, and so forth. Well, what you can do is you have a cause of action. Now, in the general sense, account is a cause of action. Okay? So that's in the general sense. But you can label something as a cause of action, say what the facts are, and then in the count, you have your theory as to why that's wrong. Now, you could have a second count on the same cause of action with a completely different theory, and the second theory could be in total conflict with the first theory. Doesn't matter. It's okay to have conflicting theories. If you don't get them one way, you'll get them the other. That's basically what it boils down to. But so you can have conflicting theories in your different counts. It's okay. That's a long settled question in law. There's also, you can have several counts which are basically separate causes of action. Not even the same facts, different facts. Okay? So what it really comes down to is how you choose to label things. So now there is a rule, long-standing common law court procedure rule, against duplicity. That means that you don't want to be repetitive. You've said something once, that should be enough. No need to repeat it. So if you have different counts and they're basically saying the same thing each one, then that could be thrown out. Okay? And even if your court says it's okay, you might have trouble getting the cooperation of the rest of the world. So you don't want to be duplicitous in your writings. So, but you can have the same facts and different theories as to why it's wrong. Whatever. For example, you could have one where you call it a misdemeanor and another one you could call it a felony. That's if you were running a criminal case. But anyhow. Okay, you got trover. Basically, that's a form of action which lies to recover damages against one who has without right converted to his own use goods or personal chattels in which the plaintiff has a general or special property. So, bottom line, somebody had your property, had your TV set and sold it. You lent it to him expecting to get it back, and instead he sold it. That's called conversion. And so this becomes an action for trover. Detinue, a form of action which lies for the recovery in specie. In specie means of money, I think. Of personal chattels from one who acquired possession of them lawfully but retains it without right, together with damages for the detention. So you're basically suing for the item, or for the money, I guess. That's the specie. And then you also want additional money because he detained it. You want damages for that. Replevin is when you want the actual object back. And replevin does not have damages. It's simply an action to get back the property. Some people have used replevin very successful in getting properties back from that the police have confiscated. Okay. Debt basically has to do with somebody owes you money. That's simple. Okay? It doesn't matter why they owe you money. It's just the fact that they do. Let's say somebody signed a note. You sold them a property, and they signed a note to pay you later. Now they owe you the money. It absolutely makes no difference what it was you sold to him. Okay? The fact of the matter is that he owes the money, so that you sue for debt only. Now, I suppose if you sold him drugs that were illegal, he could come back with and say, well, you had no rights, you know.
Illegal according to whom?
Well, the government, it is a principle of law that if you're doing something illegal, you can't expect to be rewarded for it. So, or unlawful. If not illegal, it's unlawful.
Statutorily unlawful?
No, unlawful, you meant illegal. Unlawful automatically means common law. So let's see. We have covenant. Covenant is where you have a contract that's sealed with an actual seal. Or as somebody brought up, a signet ring, on wax. If you have a contract sealed, you're trying to enforce the contract, covenant is the action. On the other hand,